Good afternoon, and welcome to the Matthias Corvinus Collegium. Today I'm joined by two distinguished legal scholars and legal practitioners, Rodrigo Ballester and Ilan Wurman, and we will be talking through a theme that discusses the future of Europe. But we will start most likely with some sort of American constitutional questions regarding Ilan Wurman's new book and his previous book, and then get over to how this relates to the European Union with Rodrigo. Before we get into it, let me introduce myself. My name is Balázs Mártonffy. I'm the director of the American Studies Research Institute at the University of Public Service here in Budapest. And let me introduce our two scholars. Rodrigo Ballester is the head of the Center for European Studies here at the Matthias Corvinus Collegium. He holds a law degree from San Pablo University in Madrid and an LLM from the College of Europe in Bruges, I'm so sorry. One of his most defining features is 16 years in various capacities with the European Commission. And he's also an invited professor at the Institut d'études politiques de Paris at the Dijon campus, where he teaches European law. Ilan Wurman is an associate professor at the Sandra Day O'Connor College of Law at the Arizona State University. He teaches administrative law and constitutional law. He is an author of numerous publications, too many to list, but perhaps the one that I would like to point out is The Second Founding, an introduction to the 14th Amendment, published by Cambridge University Press, which is one of the books we'll be talking about today. I'm a political scientist, so I have the luxury of moderating a panel talking about law and legal traditions, but the questions I pose will mainly be relegated to how power comes into it and who holds the power in law. But let's start off with you, Ilan, today. First off, we know from the news, the media, that there's always a debate about how many conservative versus liberal justices sit on the Supreme Court. My understanding as a political scientist that this is somewhat of a misnomer, that conservative doesn't quite cover the term originalist versus living constitution. And hopefully, if I got this right, your first book, also from Cambridge University Press, describes this. Can you provide us a brief intro into what originalist versus non-originalist understandings of the US Constitution are?
Sure, and this debate might seem quite foreign to Hungary, which has a very new constitution, but there are two general schools of thought in the United States as to how to interpret the Constitution. One, which tends to be favored by conservatives, but not necessarily, is called originalism. It's basically the idea that we interpret the Constitution with its original meaning, with its original public meaning. And when you think about it, this actually makes a lot of sense. After all, the Constitution, it's not a novel. It's not a poem. You don't interpret it poetically. It's not a Socratic dialogue. It's not, a code of military instructions, secret military instructions. So how do you interpret a constitution? How do you interpret a legal document? Well, the same way you'd interpret a public instruction, like a cooking recipe or a baking recipe, and that means you interpret it with its public meaning, not a secret meaning or esoteric meaning or poetic meaning or ironic meaning, right? It's a public meaning, and it's the original meaning, the meaning the creators of this document had at the time when they wrote it and conveyed it to the public. Now, this all sounds obvious, perhaps, to a Hungarian audience. By the way, it's a great pleasure to be here in Hungary, so thank you for having me here. After all, the Hungarian constitution is only 10 years old, 9 years old, maybe. And so, of course, you interpret it with its original public meaning. But in the United States, the Constitution is 230 years old, and it's very, very hard to change. It's very, very hard to amend. So in that context, there is a group of scholars and judges who argue that the Constitution should instead be interpreted as a living, breathing document that judges, not the people, not through the amendment process, which is difficult, but judges themselves can update the meaning and content of the Constitution over time, to make it more relevant to modern times as the judges see it. And so that's called living constitutionalism, and that's the debate. My first book, A Debt Against the Living, is a defense of originalism. And so to go back to your first question, conservatives tend to like originalism. Liberals tend to like living constitutionalism, but there's not a necessary connection because the original Constitution doesn't compel conservative results necessarily. I mean, think of perhaps the same-sex marriage debate. I think the conservative position is it's up to the states to decide, right? Where liberals can win, libertarians can win, conservatives can win. It doesn't necessarily lead to conservative results, but the conservatives tend to favor it.
And I think that segues perfectly into your second book, Up to the States to Decide. It's only a 150-page book, so I did glance into it.
145.
I'm so sorry. Specifics are important. 145 pages of excellent writing and even better editing. But so the question becomes, if I understand the title of your second book correctly, and sort of the theme of our topic today is Up to the States to Decide. I think that was your word over here. This book is about the 14th Amendment, and it has caused quite a kerfuffle in legal scholars' circles, wide and varied that may be, but it even broached our interest when we read this book. So tell us a little bit about the 14th Amendment. What are the pushbacks? What are the views on it? And how does your book fit into this larger debate?
Yeah, so the 14th Amendment wasn't part of the original Constitution. The original Constitution had this problem, this original sin of slavery. After the Civil War, the 13th Amendment abolished slavery. And then the question arises, what do you do with the newly freed people, the newly freed population in the South? And the South continued to discriminate, deny civil rights to the newly freed men and women in these infamous black codes, as they were called. And the 14th Amendment was part of the solution. And the 14th Amendment first declares that these newly freed people, these free blacks, are citizens of the United States. And this overturns an infamous and notorious decision by the Supreme Court in 1857. So it starts with all persons born or naturalized in the United States and subject to the jurisdiction thereof, right? So you can exclude ambassadors and things like that, are citizens of the United States and of the state wherein they reside. And then it goes on to say that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, there are two other clauses which we'll talk briefly about. There's a due process clause. It says the states can't deprive someone of life, liberty, or property without due process of law. There's an equivalent in the Hungarian constitution, by the way. And it says, nor shall any state deny to any person within its jurisdiction the equal protection of the laws, legal protection. And this is also, by the way, in the Hungarian constitution, something similar to this. And the controversy, my book centers on, it's a holistic look at what the legal meanings of these provisions were, due process of law, the protection of the laws, and the privileges and immunities of citizenship. But for purposes of today, the focus of the book is on this privileges or immunities clause. There is a debate in the United States over what we call the incorporation of the Bill of Rights. So everyone hears about the Bill of Rights in America, the First Amendment, free speech, the Second Amendment, gun rights, Third Amendment, quartering soldiers. We don't really, never been litigated. We have unreasonable searches and seizures, due process rights, cruel and unusual punishment. And historically, the Bill of Rights only applied against the national government, the federal government. It did not apply against the states. However, over the course of the 20th century, the Supreme Court began incorporating, what we call incorporating the Bill of Rights against the states, and forcing all 50 states in the United States to abide by the requirements of the Federal Bill of Rights that used to apply only to the federal government. Now, this used to be hugely controversial. Right? It was controversial first among conservatives. Why? Because when incorporation was taking place, in the 1940s, 50s, 60s, and 70s. This was also the era of judicial activism, of overwhelmingly progressive judges expanding the rights in the Bill of Rights, making up rights in the Bill of Rights. So there's a case that says a state can't prohibit a married couple from using contraception in the home, Griswold v. Connecticut. And some of the justices said, well, it's not exactly in the Bill of Rights, but it kind of sort of follows from some of the rights, some of the protections in the Bill of Rights. And so the same thing with criminal procedure. All of a sudden, the Supreme Court's interpretations of certain criminal procedure rules said you have to exclude evidence suppress evidence if it was unlawfully obtained. This is nowhere in the Fourth Amendment. It's not required by the Bill of Rights. So in this time, the Supreme Court seems to be getting the Bill of Rights wrong. It seems to be making up these rights and then applying them against the states. So this used to be controversial. It was recently controversial, by the way, among liberals, among progressives in 2010, when the question was whether the Second Amendment, gun rights, the right to bear arms, the question was whether that should be incorporated against the states. Then the liberals all of a sudden didn't like incorporation. Okay? But overwhelmingly, this debate's over now. Overwhelmingly, the public supports the incorporation of the Bill of Rights, and overwhelmingly, originalist scholars argue that the Bill of Rights was correctly incorporated under the original meaning of the Privileges or Immunities Clause, right? Which again says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. What are the privileges and immunities of citizens of the United States? Sounds like the Bill of Rights, the First Amendment, Second. So it's plausible. Well, my book argues that everyone is wrong about this. That the Privileges or Immunities Clause was not intended to incorporate the Bill of Rights against the states, that it was actually an anti-discrimination provision with respect to civil rights under state law. In other words, if California wants to ban handguns, I think it can ban handguns. But what California can't do is say, well, only African Americans can't own handguns. You can't do that, because if you allow people to bear arms as a civil right, then you have to treat all your citizens equally. You must all give them that right. So the implications for incorporation are quite obvious. I think it means California can experiment with guns, it can experiment with corporate speech, right? And a more conservative state perhaps can get rid of the exclusionary rule, the suppression of evidence. And so there's something in it for both liberals and conservatives, and I think it would, God forbid that we allow the states to experiment a little bit with the scope and nature of these rights, of these fundamental rights. So that's the argument of the book. If we have time, I'll happily spend a few minutes talking about, how I get to that conclusion. I will say that I think two other living scholars agree with my view of the Privileges or Immunities Clause. We are few in number, but we have the virtue of being correct, at least.
Well, I think we do have a couple of minutes, so we would love to hear your theoretical and sound argument, specifically the methodology, because I did read into your book and you use somewhat different evidence to support your claims. But not only the Privileges and Immunities Clause, but also the Due Process Clause and the Equal Protection Clause, if you can get into that just a little bit. Yeah,
I'll try to keep it short. It's the whole book, right? But fortunately, the book is also short, but I'll try to be shorter. So there is sort of a methodological debate at what evidence do we look to figure out the meaning of the 14th Amendment, which was written in 1866 in Congress, the 39th Congress. It was ratified by the people in 1868. So some people look for specific statements made by the legislators in the 39th Congress, over 1,000 pages of legislative history. They find one thing and they're like, oh, this supports my view because some guy said this at some time in the debates, right? And so there is a debate in American law more generally. Do you look to legislative history in interpreting statutes? We have a judge, former judge, Judge Harold Leventhal, once joked that using legislative history to interpret statutes is kind of like going to a cocktail party, looking over the crowd, and picking out your friends. You just pick and choose the ones you like. Well, my approach is very different. So a lot of the scholarship looks to legislative history and tries to understand that. There are other approaches, of course, but mine looks to legal history. Not legislative history, but legal history. The claim is that these provisions, due process of law, the protection of the laws, and the privileges and immunities of citizenship have these long antebellum, that is pre-Civil War, legal meanings from Magna Carta in 1215, which predated your Golden Bull by 7 years, by the way, but it was close, right? Through the statutes of King Edward III, to the Petition of Right of 1628, to the Bill of Rights of 1689, to William Blackstone's commentaries on the laws of England, to antebellum state court cases. And when we look at these meanings, these historical legal meanings, and combine them with what we know the 39th Congress was trying to accomplish, the conclusion is inescapable that the Privileges or Immunities Clause doesn't incorporate the Bill of Rights, but rather just requires a state to treat its citizens equally. But otherwise, it would let the states experiment with the scope and nature and content of rights. So the key to the puzzle is the Civil Rights Act of 1866. We know it is conventional wisdom, and here I actually agree with the conventional wisdom. It's the only point I really agree with the conventional wisdom on, is that the ratifiers, the framers and ratifiers, the authors, I should say, of the 14th Amendment, sought to find a constitutional basis for the Civil Rights Act of 1866. The Civil Rights Act of 1866 was enacted by Congress to try to abolish the black codes in the South. These are the codes that I had mentioned that said things like, if you're a free black person, right, a former slave, now freed after the abolition of the 13th Amendment, you're not allowed to own guns. It said persons of color cannot carry, own, possess dirks, daggers, swords, firearms, or munitions of any kinds. But white people could. White people could. If you were black, you couldn't own property. You couldn't own a house. You couldn't own land. White people could. So the Civil Rights Act of 1866 declared, enacted by Congress, that all persons born in the United States, okay, and it excludes Native Americans who weren't taxed, and if you were subject to a foreign power, like ambassadors, otherwise all persons born in the United States are hereby declared to be citizens of the United States. And then it says such citizens, right, such citizens of the United States shall be entitled to the same right in every state or territory to make and enforce contracts, to sue and be sued, to hold and convey property, as is enjoyed by white citizens. Note what the Civil Rights Act of 1866 does and doesn't do. It doesn't guarantee any of these rights at all. It just says if a state gives these rights to white citizens, it must give them to black citizens and other citizens, free of arbitrary discrimination. Note also the terminology. Right? It declared these people to be citizens of the United States, and then says such citizens. Again, such is a cross-reference back. Such citizens of the United States, as a virtue of their U.S. citizenship, have the right to equality in state civil rights. So when people hear in the Privileges or Immunities Clause in the 14th Amendment, right, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, they think, oh, Federal Bill of Rights, National Bill of Rights, right? Citizens of the United States. It sounds like it's referring to federal constitutional rights. But in the Civil Rights Act, they say citizens of the United States and says, here are your privileges. You're entitled to equality with respect to civil rights under state law. So I think that's what the Privileges or Immunities Clause does. The Privileges or Immunities Clause was intended to constitutionalize, put in the Constitution, this Civil Rights Act, effectively, which requires anti-discrimination. I'll be very brief on this next point. Well, I'll try. I'll be a little bit brief on this next point. The biggest counter-argument to my claim is the Equal Protection of the Laws Clause. Everyone says, oh, there's an Equal Protection Clause. Equal protection is what requires equality. And today it does. Today, under the modern doctrine, all the equality jurisprudence of the United States Supreme Court is done under equal protection. Well, if this were an audience of law students in the United States, here is when I would say, everything you learned about the Equal Protection Clause is wrong. Okay? Equal protection doesn't mean equal laws. It means equal protection of the laws. What was protection of the laws, or legal protection in the case of the Hungarian Constitution? In short, it was the flip side of due process of law. What was due process of law? Due process of law said the government can only take away your rights, life, liberty, and property, under two conditions. There must be established law. In other words, they can't just say, Balázs, you jaywalked yesterday. We know jaywalking isn't a crime, but we don't like you, so we're sending you to prison. No. The law must be established in advance. And if you violated the law, you get a hearing, an adjudication, right? And those are the only two requirements. The protection of the laws was the flip side. It was the legal protection that the government had to give you against private interference with your rights. It was the legal protection the government gave you against other private citizens that tried to interfere with your rights to life, liberty, and property. So the quintessential violation of the protection of the laws was mob violence. When you got mobs, these big crowds that lynched abolitionists, that lynched black persons, that was the quintessential violation of the protection of the laws. The protection of the laws, in other words, required protection from private violence and judicial remedies. If a private person interfered with your rights, trespassed on your property, committed an assault against you, converted your property, you need to be able to recover against that person in a court. That's what protection of the law means. Okay, don't believe me. I'm young, you know, just starting off sort of in my career. Take it from two more established authorities, William Blackstone and Chief Justice John Marshall. William Blackstone, in his commentaries on the Constitution, said the method of recovering and asserting rights when wrongfully withheld is what we mean when we speak of the protection of the laws. Judicial remedy for private interference with your rights. Chief Justice Marshall, in Marbury v. Madison, this famous case from 1803, said, the very essence of civil liberty consists in the right of the person to claim the protection of the laws whenever he receives an injury. Legal protection and due process of law don't require equal rights. Your rights could be terribly unequal. All it says is whatever rights you do have, you're entitled to legal protection from private people trying to interfere with your rights. And we, the government, will only take away your rights, however minimal they might be, will only take away the rights you have according to established law and known procedures. Why do I mention this? It should be clear now that the Equal Protection Clause in the Constitution and the Due Process Clause in the Constitution, they don't constitutionalize the Civil Rights Act of 1866. Again, your rights could be completely unequal. Something else must do the job. And the answer must be the Privileges or Immunities Clause. And if I'm right about that, that means the Privileges or Immunities Clause requires a state to treat its citizens equally. But otherwise, it can decide what kind of contract rights does it want. Does it want to say, you can't work more than 10 hours in a day because we think too much work is unhealthy? Yes, it can do that. What it can't say is, you know, only Asian Americans can't work more than 10 hours a day because we don't want competition from them. Right? That you can't do. You have to treat them equally. But if you want to, as a state, experiment with gun rights, speech rights, criminal procedure rights, contract rights, property rights, you're welcome to do it. You just have to treat your citizens equally. And that's why I think it doesn't incorporate the Bill of Rights against the states. And again, I mentioned this before, wouldn't the world be a bit better? And here maybe, you know, Rodrigo will have something to say in the European context, but wouldn't the world be a bit better? Like, God forbid that California experiments with banning handguns. Let them do it. You know, God forbid that Texas gets rid of the exclusionary rule. You know, so criminal defendants who, you know, you find the murder weapon in the home, you know, you don't exclude that evidence if they, you know, the search was unlawful, if they didn't get a warrant, you know, if they didn't dot their I's and cross their T's. God forbid that there'd be some experimentation in the scope and content of these rights at the state level. And so that's the claim.
Well, that is extremely interesting. Thank you for the very apt and succinct synopsis of a 145-page book. And before we turn to Rodrigo, because I think there are a number of parallels that can be drawn between the EU and some member states, if not all member states. So if I get this right, you can say that, and I did jaywalk yesterday. I don't know how Ilan knew that, but shocking that you knew that, or a good guess. That you could say that Georgia can say jaywalking is no longer a crime, as long as it applies to everyone in Georgia, right? That would be sort of the broad reading of that.
Sure, I'll do one better, if I may, with that example.
Sure, what if but Georgia... please don't tell them what I did else yesterday. So that's the only thing I ask.
What if Georgia passed a law that says if you jaywalk, the punishment is death? The punishment is death. It sounds crazy. It sounds unreasonable. And under modern Supreme Court doctrine, the Supreme Court will just say, oh, that's too excessive or something, you know, cruel and unusual punishment under the modern Eighth Amendment. But suppose Georgia abolished its own version of the Eighth Amendment, because I'm sure they have one, got rid of that, and then said, if you jaywalk, we'll punish you to death. There is nothing under my reading of the Constitution that would allow the Supreme Court of the United States to interfere with that. And at the end of the day, why do we care? Because if the law is so crazy and so unreasonable, isn't our protection as citizens to be found not in the judicial process, but in the legislative process? If it's so crazy, why would we, the people, have agreed to send representatives to the legislatures to enact these crazy laws? And that's the point.
And that's an excellent point, and we get into process versus substance and separation of powers and all that stuff, but you sort of went up and beyond my question on the jaywalking one. What my true question was, who could prove that you were right? or whose verdict, you mentioned two famous legal scholars, we're getting to Rodrigo in just a minute, who would you say can definitively say, and this is the political scientist in me asking, who has the power to say, Dr. Wurman, your interpretation is correct, and everyone else, who my understanding is you're in the minority in this reading of the 14th Amendment, who would you say can definitively say that?
There's no such authority. At the end of the day, it just depends on whether I can convince enough people that I'm right. And I am slowly but surely doing that, I think.
So the court of public opinion, you would say?
And court of judicial opinion. My book has already been cited in one case, a big abortion case out of the Sixth Circuit in Ohio, Cincinnati in the United States. And I hope they continue to look at it carefully, especially, you know, the reality is the Supreme Court is unlikely to revisit the incorporation of the Bill of Rights. I once asked Justice Antonin Scalia, this big originalist, textualist, what do you think of the incorporation of the Bill of Rights against the states? And his response to me was, I'm an originalist, I'm not a nut. I'm not crazy. I'm not about to tell California that it can, you know, prohibit, you know, speech or something like that. So the chances of this actually happening, you know, and convincing judges is pretty slim. But look, I'm an academic. I get paid the same. So.
Well, okay, I think that might be the proper turn of events too. The European Commission workers getting paid the same and all that stuff. That is an extremely interesting remarks by Dr. Wurman. Rodrigo, how do you think this applies to the European Union? I have a number of ways I can draw parallels, but I don't want to bias you. As we can see, anchoring bias, just because the Supreme Court decided on it this way earlier, has notable influences on the future. So I don't want to bias you at all. What do you think are the parallels?
Many than far more than I thought, actually, Balázs. So first of all, thank you as well for being with us and for moderating this event. Thank you, Ilan. It's a crash course on the American constitutional law. I'm always, you know, very, very careful with drawing parallelisms between the US and the European Union, because I think normally, like, really the starting point is totally flawed. But, you know, when you started speaking, I was listing 1, 2, 3, 4, 5 points that really, really sound very, very familiar in the debates we have now on the future of the European Union. You know, we have this big conference now. We have 1 year to react to it, and I think it's also very, very important that all voices are heard, you know. Voices also beyond Brussels and beyond the Brussels, you know, like usual circles. And I think this discussion today, you know, when we can compare actually the United States of Europe and the non-United States of the European Union, so basically the European Union as such, is extremely important. And the first parallelism, you know, is that when I was listening to you, Ilan, is like, I don't know whether such a thing like a European originalist exists, but I might be the first one. Because it's...
Converted one person, that's good, that's good.
Because no, indeed, you know, sometimes, you know, those who have a more critical point of view on the European Union, on the mainstream European Union, you know, we sometimes, you know, listen to, for example, the Schuman Declaration. It's like the very, you know, foundation of the European Union, which was basically a very short speech given in '51. And when we hear Robert Schuman speaking about the pragmatic approach, the small step approach, the interest of the member states, you know, we look back and say, where are we now with that? When we hear, for example, about the importance of the principles of subsidiarity, we'll come back to that, of conferral of competences, you know, again, cardinal principles within the European Union. And when we see, for example, we compare them with the case law of the European Court of Justice and how they interpreted our Bible, which is the Treaty on the European Union, then we start doubting. And we start having doubts. And again, it's very much the case, you know, when we come back a bit to those origins. You know, like a lot of people, they like to ask, okay, what would Robert Schuman or Jean Monnet think if they will wake up today? Well, certainly there will be a great deal of pride, huh? Because it's true that I don't think they ever imagined that the small organization they launch on 2 products, basically coal and steel, will go that far. They will be probably very proud to see that now we have solidarity mechanisms, that, you know, this European Union is basically a machine for prosperity. It also brings some political stability. They will also be very happy to see that we can circulate, that we have Erasmus programs and things like that. But on the other hand, I'm pretty convinced as well that Robert Schuman would also ask some cheeky questions. What about member states? What about subsidiarity? What do you mean by common values, by the way? Where is the political diversity that was really very much in the core of my original thinking? And so, they could start asking those questions if they were with us. I wanted to react, I noted 4 points. First, I went a bit on subsidiarity because it sounds a bit like the 14th Amendment. It's up to the states to decide. Up to the states to decide. This is basically, if I had to give it a European translation, we will call it subsidiarity, which is one of the principles we have here in the treaty. And it's an old medieval principle, from the scholastics time, from Thomas d'Aquino. And, so it's a very old philosophical principle, which basically tells us, to European thinkers for already 1,000 years almost, take the decisions as close as you can to the citizens. And when you put it in the European context, of course you have to think about it. Let's speak also a bit about the principle of conferral of competencies, Article 5, exactly in the same article here. I would like also, I have to do it, to speak a bit about also the judicial activism of our European Court of Justice. I thought we were the only ones. No. Actually, I think we are still lagging behind in terms of EU judicial activism, but still, is it already too much? I think that's a very, very fair question as well. And so also, okay, can we also go back to the origins? And no worries, if you're an ultra minority among the originalists, I am the only one so far, so I'm even less than that. And also, to speak a bit about political diversity, because sometimes I have the impression, Balázs, that the more the European Union enlarges, the more it stretches its, political laying foundations. And so the less diversity is from a political point of view. And I think this point on diversity is also very important because diversity is a word that we hear a lot today. And we can also, run the risk of having persons from different sizes, different genders, different sexual orientations, different races, everything. But at the end, they end up thinking the same thing, as if there was only one way of looking, at very complex realities. So for me, diversity means, first and foremost, political diversity. More than the color of your skin, what I like is, the diversity of your brain, basically. And this is something that is cruelly, lacking today. Subsidiarity and conferral of competencies first. Article 5 of our Treaty on the European Union. One of the most important principles, subsidiarity, basically, let me read it if you want, means that you have to take the decisions as close as you can to the citizens. In legalese, in European legalese, it means that in areas which do not fall within its exclusive competences, and I spare you like the divisions between mixed and exclusive competences, the Union shall act, and this is where it gets important, only if and insofar as the objectives of the proposed action cannot be sufficiently achieved by the member states, either at central level or at regional and local level. So we have one of the most important provisions of this Treaty on the European Union that mentions not only the national level, but also the regional and the local level, the municipalities. Impressive, remarkable. How do we implement that? That's basically the question. We have a protocol on that in this Bible as well, Protocol 2. And the way protocol speaks about principle of subsidiarity, I would say, goes in the right direction. I would say, it takes it seriously, speaks about a very, very, specific impact assessments every time the Commission or anyone else, but mostly the Commission is putting a proposal on the table. They really need to take this impact assessment seriously, for example. And so basically this question that if and only if must be answered, seriously. Personally, have doubts that this happens. When you read the impact assessments, when you read even the annual reports on subsidiarity, even when you read, what we call impact assessments is basically like the very, very long report that the Commission produces before starting drafting a proposal of legislation. Sometimes it's there, but sometimes it's not. And sometimes, the way, you can read it at least in the proposals, it looks a bit too formal to me. It's basically, a couple of paragraphs, sometimes even standard paragraphs saying, this legislative proposal respects subsidiarity, full stop. So being a bit too descriptive, when actually sometimes you have a lot of points to be discussed there. Do we discuss them properly or not? I don't know. First question. And then when you speak about subsidiarity, it's not only, the legislative proposals, you also have to make sure that there is a culture of subsidiarity in the European Union. One thing is to tell to the European Parliament that they cannot, have a resolution, I don't know, on imagine on the situation in Spain or the situation in Ireland, even if it's not within their competencies, a parliament is sovereign, they can speak about whatever they want. And it's true that you also have city halls, doing declarations, I don't know, on Israel or on climate change or whatever. So that's a question. But for example, what I miss sometimes is that the European Commission doesn't have this culture of subsidiarity that, leads to a certain prudence, when, it basically tries to intervene politically in some issues that have nothing to do with the competences, according to this book. And so I miss also not only the subsidiarity as a legal principle, but I also miss it as a, as a culture, as a mentality, as a mindset. And that we don't have. And that's dangerous as well, because, in some ways we are more integrated than you. We already spoke about it, but still we are speaking about 27 different member states. And when you give the impression to the citizens that from very far above in Brussels, they are trying to preach them about things that can be so national and so sensitive and so diverse as all the social agenda, think about transgenders, about gay rights, about, and you name them, basically all of that. I don't think that this is a tendency that is going to strengthen the European Union. And Ilan, as an American, you have to know that basically my worst nightmare personally is that the European Union disappears. That will be a historical tragedy that you cannot even calculate the consequences of. But I have the impression sometimes that this respect for this culture of subsidiarity is precisely one of the recipes to suicide. And that's why I think we should also again go back to the basics, to the classics. Huh? The Treaty of Lisbon that I have here on my laps also introduced in this protocol too, the role of the national parliaments, which is not a bad idea as such, to associate the national parliaments, to the decision-making process that occurs in Brussels, mostly through the co-decision, the ordinary procedure, makes sense. But again, it falls, below the expectations, because some call it a yellow-red card system. I would call it a pale yellow, and very pale orange system, because at the end, only if 1/3 of the parliaments, raise their hands in one direction, that obliges only the Commission to basically reassess if they want to. And only if, you have half of the national parliaments, which is a uber majority, something that is very, very difficult to get, only in that case, the Commission is obliged to reassess it. So it might not, it has to reassess it, but then, it goes again to the European legislator. It's often the case in the European Union, you have promising reforms that actually end up in very disappointing results. And I'm afraid that this protocol, at least when it comes to the role of the national parliaments, is also a bit the case. Let's speak also about the principle of conferral of competencies. And this one, I like it even more because it's even more neglected. At least people speak about subsidiarity. Everyone knows it's part of the European jargon. But when it comes to the principle of conferral of competencies, I really have the impression that this one is blithely ignored, especially by the European Court of Justice, by the way. Not only, but basically, here, Article 4, competences not conferred upon the Union in the treaties remain with the member states. That's for me...
Like the American 10th Amendment.
Exactly. It's basically the European equivalent of the 10th Amendment. So that's why, this discussion makes so much sense. It makes so much sense. And also, look at Article 5, Paragraph 2, under the principle of conferral, the Union shall act only within the limits of the competences conferred upon it by the member states. It's pretty clear, no? What about that? There, my impression, again, that deserves a serious research and very, very accurate and thorough one. I don't think that the European Commission puts on the table European legislative proposals, that are in breach of that. They must put a legal basis. Legal basis can also be interpreted, it's true. But, at the end, they have to justify themselves. But I have more doubts about the European Court of Justice. My impression is that when the European Court of Justice is dealing with very technical affairs, it stays within the frame. But when, it has the occasion to behave a bit like a Supreme Court, American free, I think there's also a psychological Freudian thing there, then it's not that they miss the occasion, it's that they overdo it. This is also part of the European construction. Think about the classic principles of direct effect, Van Genderen-Loos case, primacy, Costa Enel, and especially Internationale Handelsgesellschaft, which for me remains like the case on primacy, and many others, So we can have a discussion on primacy, for example. You know, primacy, Ilan, is a principle that is older than you and me together, but that is still very much discussed and actually, you know, like contested by a lot of Supreme Courts, national Supreme Courts here. And they didn't do that only 30 years ago or 40 years ago. They did that a couple of weeks ago. You know, when, for example, the German Constitutional Court had to give its go-ahead to the recovery fund, so the fund that is supposed to bring back Europe on tracks after the crisis, that happened a couple of weeks ago. Basically, that was this contestation of primacy. You know, the German Constitutional Court always said, on several occasions, guys, if you go too far, we're going to keep an eye on you. And as long as you respect that, the Zolange cases, and that's very old already, we are not going to say anything. But if you don't, we will have the last word on that. So you see, primacy, for example, that if you learn it only from the European perspective, it's a given. Actually, it's not, and has never been. So the law indeed can be very political and can be very, very live. So primacy is also another, you know, like a classic, you know, and I can understand the reason behind primacy, but I understand it even better if it comes together with a strict limitation of competences. And when you have, for example, an article like the Article 20 here of the Treaty on the Functioning of the European Union on citizenship, that says clearly that within the scope of application of the treaties, which is one of the classic, you know, like boundaries that of European legislation or European law in general, whatever you do, you have to do it within the scope of application of the treaties, not beyond. And when you see that this cardinal principle is largely ignored on citizenship by the European Court of Justice, look at the Fambrano case, look at the Coman case, also that from 2018, where basically, you know, the European Court of Justice, you know, together always with the excuse of defending fundamental rights, is basically ignoring what is happening here. You want another example? I might not agree too much with this example, but it exists, and a lot of German citizens, for example, have that in mind. According to the treaty, the central bank is not supposed, you know, to lend money to the member states. And a lot of very good faith German citizens think that it has been doing that since 2010 at least. What about that? Because again, if you have a much stronger national cohesion, we don't. If at the end you give the impression to the demos that the people up above are not respecting their own rules, what's going to happen, you know? What's going to happen?
Can I ask you about the conferral of competences? So in the United States, of course, we have the 10th Amendment, and then we also have a specific conferral of competences on the national government in Article 1, Section 8 of the Constitution. We call it the Enumeration of Powers. But there's a debate over this in the United States too. And the debate principally occurs because there are two powers that Congress has that, let's say, are amenable to broad and ever-expanding interpretation. So the first one is Congress has the power to regulate commerce among the states, interstate commerce. What is commerce? Well, when it was written in 1789, it was, okay, the contracts for sale, buying and selling, bartering. What was not commerce? Production, agriculture, manufacturing, right? Things like that. There were things that preceded commerce. Well, then over time, in the New Deal in the 1930s, the federal government tries to do more and more. It tries to regulate internal matters, internal production, wages and hour laws, which, again, that's not commerce. Like telling California that it has to have a minimum wage, that's not commerce. Historically, that was production or labor or manufacturing, and it was internal to one state. It wasn't interstate commerce. So how does Congress have this power today? Well, the Supreme Court said, well, these things affect commerce. And so, well, what doesn't affect commerce eventually? So there's the famous case, it's called Wickard against Filburn, where a farmer, Farmer Filburn, Wickard, in case you want to know the government agency on the other side. So Farmer Filburn basically grew wheat on his own farm for his own consumption, in violation of quotas established by the national government. Well, the national government came and fined him from producing wheat in excess of the quotas established by the national government. And he challenged this under the Commerce Clause. And the Supreme Court said, well, yes, it isn't commerce, and yes, his contribution alone doesn't affect commerce, but if there were too many farmer filburns producing their own wheat, this would reduce demand for wheat in the interstate market. Reduce demand for wheat in the interstate market changes the price for wheat, and that's commerce. So now we have something called the substantial effects test. If an individual does something that in the aggregate eventually affects commerce, Congress has the power to do it. So today we say Congress has the power to do basically anything under the Commerce Clause. Yeah. Is there a similar provision in the European context that the European courts seize on to expand their interpretation and extend their power in that way, in a similar way?
There is not a specific provision, but the European Court of Justice does it anyway. This is what we call like the connecting factor. And basically, you can be very elastic as a chewing gum whenever you want something to be within the competence of the European Union. It happened, that in some cases, I remember the case Carpenter, for example, where the European Court of Justice really decided in order to save basically this lady, Mary Carpenter, that again is a case on citizenship, the connecting factor with European law was, like as thin as a hair of mine, basically. And so they did it. And so it's true that this connecting factor, can be, when you put it in the hands of judges and you don't have really a counterpower to correct that, because it can be a very human and very natural tendency. I mean, judges are judges, with their qualities and their default everywhere, and you cannot ask them to be machines neither. But it's true that what I miss there, is that you said before that it's extremely complicated to amend your constitution. I don't know, Balázs, is it more or less complicated to amend a European treaty?
Than the US Constitution?
Yeah.
I think that depends on how you want to amend it and how long you want to amend it and how long you want to do it for. So I think one of the reasons I hold to book this thing is that's pretty simple, right? You have a 800 page?
No, less.
Less.
You
Pretty
can
long.
read it in 2 days.
I don't know. I'd say that's an extremely interesting question. It boils down to efficiency, efficacy, the value of diversity, and how we get to that.
And the procedures, all the referendum that you need sometimes and things like that. But anyway, open question, but it's not easy to amend this one. And so at the end, when you have a text that is not so easy to amend, and you have, at the end, the last referees are judges, like it is in the US, but also to a certain extent the European Union, you can, those distortions can definitely occur. And actually, Ilan, this is another point that you basically put a bit in between the lines, but that is very important in the European Union now, is also, political diversity. Basically, you gave the impression that through the interpretation of the 14th and the 10th Amendment now, on core discussions, everything must be top-down. And that echoes very much one of the debates we have here in the European Union on common values. On common values. Except that here sometimes in our case there are even less, this imposition top-down is even less, I would say, legitimate first, because it goes very much in breach of the principle of conferral of competences, and then because, it comes from a more technocratic off-ground, structure. You have 250 years, 300 years of history running through your veins. The European Union has far less. Our countries do have, some of us, have 1,000 years of history, like Hungary. Spain has 600 years of history. Some of them have actually only 30, 40 years as well. Let's not name them. But it's true that, at the end, this is something that is also bringing the European Union apart. And in a moment where, we are in the worst possible crisis now, we are facing geopolitical challenges that big. And then actually you use only these common values to create division among member states, when actually what you need is a strong cohesion among national member states to make sure that the EU can live, up to its ambitions, then I have a problem. And again, what's wrong with political diversity? What's wrong with political diversity? What I very much liked about your intervention, Ilan, is that, well, if California wants to ban guns, then fine, do it. It's your freedom, you know. You can do it as long as you don't discriminate about who can do it and who cannot. And that, you know, sounds a bit like Article, you know, 20 on the citizenship, Article 18, sorry. Any discrimination on grounds of nationality should be prohibited. I can live perfectly with that as long as it is within the scope of application of the treaties. And Balázs, look again at the US, you know. Now it's getting more and more homogenized, especially when it comes to social, you know, like legislation and values and things like that. But still on such a, you know, on such a sensitive and thorny topic like the death penalty, we're speaking about a real country that still has, you know, a diversity on such a topic, where some states have it and some states do not have it. Why in the European Union, you know, we have to hear from Brussels that basically, you know, when it comes to those common values, and I still don't, by the way, if somebody can define them a bit better than Article 2 of the treaty, I'm happy to listen to that as well. Why should we, you know, be less diverse actually than a real country like the US, where they still have a bigger sense of subsidiarity and freedom? And so you see, all what you said, you know, really resounded very, very clearly in my mind. And so that's why that with your permission, I will call myself an originalist.
Well, that's an exceedingly interesting term. An EU originalist, right? An American originalist, and a political scientist who's had the luxury of listening to these legal experts and legal scholars' understanding of how subsidiarity, conferral of competences, and all these complex terms come to life in this discussion. So it was very interesting to be part of that. Sort of from a political scientist standpoint, and the thing that I'm always interested in, okay, so what happens if one institution, if I may use this term over here, takes on too much power against something else? And what comes to my mind is obviously the War Powers Resolution, President versus Congress, who gets to wage war, who pays for war, and what goes on if Congress remains silent in what most scholars, Lewis Fisher, a number of others would say, is an abrogation of its own power. And how does the Supreme Court come in sort of an unjustifiable statement, hey, politics, figure that out? How would you respond to that, Ilan? When do you think this will happen in the debate we saw over here?
Well, I certainly think that the courts, if they're confronted with an issue of the kind that I've described, they won't step back. But there is a robust political question doctrine in the United States where the Supreme Court does say, you know, you figure it out. And usually it's when, you know, there's this initial what they say, an initial commitment to one of the political branches to make a decision, and then there's an unquestioning need to adhere to it. So there was a rebellion in the United States before the Civil War. I don't know if anyone knows about it, called the Dorr Rebellion in Rhode Island, where Rhode Island was still operating under a constitution from the 17th century. The American Revolution came and went. Rhode Island didn't change its constitution. It was very aristocratic. And some people rose up, got together in a constitutional convention, and decided that they were the legitimate government of Rhode Island. And the existing government of Rhode Island asked the President of the United States to please come call the militia to help execute, you know, there's a clause in the Constitution that says you can call forth the militia to suppress insurrection, right, and rebellion. So the President had to decide which is the legitimate government of Rhode Island. And we get this case where the militia trespasses on one of the revolutionaries, the insurrectionists, if you will, the property, and the guy sues, says, you've unlawfully trespassed on my property. And the question is, well, if we're the lawful government of Rhode Island, no, we didn't, because, you know, we're suppressing this insurrection. And the Supreme Court said, you know, we're really not going to touch this question. What happens to all the taxes that have been paid over the last 5 years if this government isn't the legitimate government? What happens to all the criminal convictions? Actually, there's a similar case. The Supreme Court did decide recently whether Oklahoma, whether something like 60% of Oklahoma is still actually Indian reservation, Native American territory. There was a case just now, and the Supreme Court decided that most of Oklahoma still actually is Native American territory. And then the question arose, well, what's going to happen to all the convictions that happened in, you know, the civil courts of the state, and so on. The War Powers Resolution is trickier. That's a whole other discussion. I don't think Congress can authorize the president to do things through silence. On the other hand, the reason we have the War Powers Resolution is because the president have been taking unconstitutional military actions in the absence of congressional authorization. So I see the War Powers Resolution, the War Powers Act, as, you know, the presidents have done these unconstitutional military actions. So Congress can't do anything about it. So Congress enacted an unconstitutional statute to try to check, you know, the president's power. All of these things are unconstitutional. At the end of the day, it's all about public perception and public opinion and political power. And that's what those are.
We get back to the court of judicial opinion, the court of public opinion, and the court of political opinion. But if I may intervene and ask Rodrigo a similar question, I would describe a sort of prudence or prudential decision-making by the Supreme Court in the United States as to when to intervene and when not to intervene into sort of unjustifiable or political issues. Do you feel that the ECJ also exhibits similar pattern of behavior, or would you say they fling to one side or the other? And I know that's a lead-in question, but that's what my gist of your...
I still have the impression that the European Court of Justice is a very reliable court, you know, when it sticks basically to its original, again, I come back to this original thing, you know, competences. I mean, whenever they have to say something about the VAT directive, for example, or about transport, about common agricultural policy, I didn't read all their case law on those topics, praise the Lord, but still, you know, the few things I read, I had the impression that, you know, it was well done, and there was a technical criteria there, very, very sharp legal things. I have the impression that whenever, you know, it's on things that are much more political, then first they jump on it with clearly, you know, like a bias for European integration, which is not their job. And second, they do it also with arguments that legally are less solid, I would say. If we want to extrapolate this question to the European Union, when it comes to if the Commission or the Parliament go too far or the Council go too far, there you have something called the European Council, basically, which is the meeting of the big bosses. So whenever you see on TV like Merkel, Macron, Orban and company, this is the European Council. And those guys don't have legitimate legislative powers, but at the end, they can frame the debates. And so I don't see any of those three institutions going beyond. What about the Court of Justice? Of course, the Court of Justice, I mean, doesn't expect, and we should, of course, not give and expect neither the European Council to give it instructions. God, you know, prevents that. But maybe, imagine that one day in this document we have a protocol saying that basically on the principle of conferral of competencies. Why not? Maybe this is one of the ideas that you can put on the website of the European Commission. Why not a protocol on the principle of conferral of competencies, for example? And then it's true that sometimes it's also a matter of mentality, you know, and simply, you know, what if the European judges, you know, will just be a bit more aware of the problems of national and internal cohesion within the European Union, and maybe, you know, we'll come back as a new school of thought, if you want, but to an interpretation of the treaty that is a bit more literal and less theological. I would be very, very happy with that.
By the way, if I may add in response to your question, I described, you know, the political question doctrine, and I want to be clear about something. It's the political question doctrine simply says there are some questions that the court won't decide and will leave to the battle of Congress versus the president, the political departments of government, the political branches of government. There are lots of political questions in the colloquial sense of political questions that the Supreme Court does get involved in, right? Whether it's abortion or same-sex marriage or the incorporate, you know, the scope and nature of rights. And all of these things could be left to the political process, to the democratic process, to ordinary politics. But the Supreme Court does get involved there because it involves fundamental rights. And my claim is that maybe it should treat those more like the political questions that should be left to the democratic process, even though they involve so-called fundamental rights, which, you know, you mentioned, you know, what are common values, right? Well, I'd like to say, at least about the the 14th Amendment under my reading, there are three very important common values. Equal treatment. You decide what rights you give, but you treat people equally. You must protect them so they can exercise those rights, protect them against private violence, and you can't take away their rights without due process of law. Those are the three most important common values I can think of. And everything else, yes, it's also common, which is why every state has a First Amendment equivalent. Every state constitution almost has an equivalent, I believe, of the Second Amendment. And again, you know, and if they're that common, then they'll manifest that way. But if they're not as common as we think, then maybe it's okay to have some diversity with respect to them.
And I think we've circled back fully to how we began. The question is, what are the ordinary political questions? What are the non-ordinary political questions? And what are common values? And given that our time is running out, all that is left for me is to thank our distinguished panelists for this very interesting conversation. Rodrigo, thank you so much for the view on Europe and the European Union. And Ilan, thank you so much for the US view. It was a very interesting comparison. I would say compare and contrast. It was good. Keep the best for both cases and go forward.
And thank you again for inviting me to this beautiful country.
I think in the name of everyone over here, thank you for coming. This was a very valued addition to the conversation over here. And with that, all that's left for me is to thank all of you for watching and thank you for joining us here today. Have a great afternoon.